All right, good afternoon, everyone, Louisiana Realtor members from around the state. We appreciate you all joining us today for a legal Zoom that is going to provide you an immense amount of information on the new practice guidelines and other areas of the National Association of Realtors settlement. Since March of this year, when the settlement was announced, the Louisiana Realtors leadership team under the leadership of Cindy Dyer, Rhonda Reap and Ginger Malden, and the executive committee as a whole has been tremendously supportive of making sure that Louisiana Realtors has taken the lead to be able to provide all Realtor members statewide the resources, knowledge, and tools they need to be able to navigate and be successful as we begin this new phase of the real estate industry. We've traveled the state, we've gone to association meetings, we've met with brokers, we've held several webinars, not only from in-state practitioners, but also from some national renowned experts on this subject. We've answered hundreds and hundreds of Q&As that have been sent in through our info@larealtors.org. We've updated our website with a broker toolkit as well as a forms library that we will continue to work on and build out as we move through this process and beyond. We brought together some suggested buyer rep forms that are recommended that we will talk about today. And we've even made a state law change in hopes of making the industry even better as we move forward under the new guidelines. So I want to thank the leadership. I want to also thank Eric Landry, Kristen Oglesby at Breazeale, Sachse Wilson for working extremely hard alongside. I want to thank Kim Calloway, our Director of Legal and Governmental Affairs, for working extremely hard as well on all aspects of providing this information, tools, and resources to you. And for that matter, I want to thank all of our Louisiana Realtor staff for manning the phones, manning the emails, making sure the questions got to the right spot at the right time so that we could respond back to you. So kudos to Lori, Cindy, Donna, and Kyra as well here at the office, and Danielle. Danielle's worked extremely hard on the website, and I think it's an easy to navigate website with all kind of information for you to go to as your go-to resource to navigate these new changes. So without further ado, the first hour today, we're going to be providing you information, Eric and Kim, about the upcoming practice changes. They're also going to talk about some form amendments and disclosure statements that we will be publishing very, very soon for active listings and buyer agreements, and addressing the most frequently asked questions that Louisiana Realtors has received from its members so that we keep things orderly. We don't, we're not going to, this first hour is going to be them talking about those issues, but don't leave after the first hour because we want then you to type in any questions in the Q&A box during this time and beyond so that we can try to get through as many questions as we can through this at least 2-hour legal Zoom process. So that's kind of laying out today, and then we'll kind of go from that standpoint. And I'm going to start by welcoming Eric and Kim as they walk you through some slides on the buyer rep agreements and other issues as it reflects the new practice guidelines. So Eric?
Yep. Thank you, Norman. I appreciate that introduction. And thanks everyone for joining in today. Hopefully this will provide some help because I know everyone has got a lot of questions about the practice changes and how to properly implement them. We've received countless number trying to answer them all. And if my camera goes out, I apologize. It's a little bit wonky right now, but we will get to answering every question as soon as we possibly can, but we wanted to focus on making sure that we got the basic elements and the basic principles of these practice changes disseminated and educated to the members so that everybody can be prepared whenever everything changes next week. So without further ado, we'll kind of jump into that. First of all, Norman mentioned the new website or the additions to the website, the forms library that's been changed with Louisiana Realtor site. So if you haven't been there, please take the time to go and check that out. Like Norman said, the staff has done a tremendous job of adding that resource available to members. And I really do think it's a great additional benefit. And so you'll see where it is right there on the website under Realtors. There's a forms library and a broker toolkit. And under the broker toolkit, you'll see,
Eric, I think your slides might, we can, at least I can see the opening slide and then the slides on the side. So I don't know if
oh,
you
okay.
started
Let me see if I can change the view.
Yeah.
Sorry.
So.
All right, hang on one second.
And when Eric's doing that, I'll just let you know, the makeup, you have 3 buyer agreements right now. You have a 1 or 2 page, a 4 page, and about an 8 page. And for every buyer agreement that there's a sample of, there's also a guidance, a guide PDF with guidance. And what that has is the language from each form. And then underneath that, there is a language where we have gone and put what NAR FAQ pertains to that and the answer to that FAQ. We've put state law and state rule that pertain to that section. And then after that, we put some things that people may want to consider when creating their forms or in their practice. So you kind of see a rhythm throughout each PDF guidance. So if you're wondering what the state law or the state rule is for that particular piece of language in any of those agreements, you can go to that guide and see the actual section. And then that's how it flows underneath.
All right, Eric, can you scroll down?
Is that better? Or is that the same?
It's the same.
All right, hang on.
Let me see if I can.
How's about that?
Yeah.
No? On mine, it looks like it's supposed to. Let's see.
We will share the slides and we are doing a recording.
Right.
For those that asked that question. There we go.
That's better?
You had it.
Had it, but don't anymore?
Yeah, it's back to the main.
Okay.
Eric, I have your PDF from last night. Let me see if I can.
Well, I changed it. Let me see. Hold on. Should be able to get it. There's got to be a setting somewhere.
A lawyer changed something. Imagine that.
Yeah, I'm sorry.
Okay.
Is it
Yeah,
better
okay.
if I do it that way?
Yep. Go back 1. There you go.
Yeah, and Eric, hit slideshow at the
Just-
top. You got your around there. Go back. Wait, move the mouse a little slower.
This one?
No, pointing at my computer. Do you see home, insert, draw, designs, yeah, right there. Click that and then go from the beginning.
Okay.
Or the current slide. Either way.
Is that working?
Just do it one at a time then.
Yeah.
Okay. Hang on.
All right.
We'll get it.
Well, when Eric works on that, I'll just kind of keep talking if that's okay. Eric's better at this, but so that's how the guidance for each form is laid out if you haven't had a chance to look at it. We've also had some questions about why did we do 3 different agreements? All of this is about consumer choice. And it's also about choices in how brokers run their business and what their agents in their office do. So we feel if we give you choice, you can give consumers choices. So what you see is there you go. Got it.
Got it. Okay. Sorry, guys. I'm just technically illiterate. All right. So here's the website, Broker Toolkit. Here's all the tools that are there and available. And we will go through some of these But some of them we are not going into detail today, but please take the time and the effort to go through and kind of click on some of this and see, you know, exactly what's been produced. A lot of time and effort has gone in to try to give you as much information as possible. You'll see on this that there is the settlement FAQs box and a written buyer agreements 101 box. Those are NAR links, and will bring you to the NAR sites where there's additional information, and those are very helpful as well if you haven't already been through the NAR website and the information that they provided. They are continually updating that and always adding new things. So please revisit it periodically to make sure that you can see what's been added and what's new, because again, they're updating it sort of almost on a daily basis, but at least weekly. We, as Norman said, have added buyer agreement forms, and there are 3 forms. There is the basic, the short form, and the long form, but just wanted to kind of give you an idea of what it looks like on the website. And we'll talk about the buyer agreement forms in greater detail, but here's where you can find that. And then in addition to the form itself is some guidance that will go along with the form. And again, we'll kind of go through this in greater detail a little bit later. But know that there's not only the form itself, but some detailed guidance that explains the form and the purposes behind it, and some of the applicable provisions of both the settlement and Louisiana law that dictate why the form was drafted the way it was drafted. So those are all available on the website as well in the same forms library area. And you'll see some additional things like the short form, the long form of the buyer agreement, and the comparison of state law between written agreements and home buyers. So all of this is available. And then, of course, we've got a box for you to provide feedback. So if you have any comments or questions about the forms, please submit that through that area, and we will try to address those as best as possible. I think it's stated otherwise in the presentation, but let me be clear. These form agreements for the buyer representation agreement are forms that are provided to the members that can be edited, modified, revised, however you may see fit. So we are not dictating that these forms be used in the format provided, and they are not prescribed, you know, by law in terms of the exact form. So you will be free to edit those and download them as a Word versions that you can easily edit those and suit them to your needs. Of course, you have to keep in mind that, you know, we also want to comply with the settlement and with state law. So there are certain things that shouldn't be revised. And again, we'll kind of talk more about that. All right. So we won't go into great detail about the MLS policies, but these are the key changes to the MLS policies that are being put into place as a result of the settlement. And this kind of a high level look at the various things, right? Number one, probably the most meaningful, is any requirements of offers of compensation between listing brokers or sellers to buyer brokers or other buyer representations must be eliminated and prohibited. So that's obviously a big one. And you'll see the third point is a very similar concept. And so is the fourth. So this is incumbent upon the actual MLS to eliminate broker compensation fields and compensation information in the MLS. So again, not going to go into great detail on these, but for these last two, which is really the crux of what we're here to talk about, which is requiring compensation disclosures to sellers and prospective sellers and buyers, and requiring you as MLS participants working with a buyer to enter into a written agreement with the buyer prior to touring a home. So these are the two big things that are directly incumbent upon you as brokers and MLS participants to comply with in terms of the settlement. And so that's kind of the key piece we'll focus on. A lot of these other rules deal with the way the MLS is managed and run, and those will be implemented by, you know, those folks in charge of the MLS itself. All right, so the first thing you'll see is the buyer agreement or written buyer agreement, and the requirement that a written buyer agreement be entered into. First, we have a new law in Louisiana. It's Act 690. And here's what it says. First, it defines a buyer agreement. And it defines a buyer agreement as a written document signed by a broker and a buyer, detailing the services to be provided by the broker to the buyer. That is all. That's all you need to do in order to satisfy this, is have a written agreement signed by both parties, and it lays out the services to be provided. So this gives you broad discretion in what that agreement might look like. It is not, detailed in terms of what needs to be or must not be included in the agreement. We do define buyer, and to be clear, we are limited to a person who you're assisting with the purchase or the submission of an offer to purchase a home, or who utilizes or seeks to utilize the services with object or purported object of entering into a contract to purchase a home. So the key part of this is buyers are those people who are buying homes or trying to lease a home or put in an offer to buy a home, but it is not commercial in any way.
Well,
and to be clear,
And Eric, let me
Yeah.
clarify, it does not have to do anything with lease, it's
Yeah,
just.
you're correct.
buy. Okay,
Right,
yeah,
sorry,
make
that's right.
sure.
And I was gonna make that clarification. So just the person who's looking to buy, not a person looking to lease. And so we've gone on to define home as residential real property consisting of not one or more than 4 residential dwelling units, each of which is occupied or intended for occupancy as a single family residence. So the intent here is to exclude commercial in any way whatsoever in terms of true commercial use, and then also to include sort of residential multi-tenant type of things that are bigger apartment buildings and that kind of property. So we tend to think that this is limited the field, so to speak, really to the true consumer, as opposed to someone who may be in the business of real estate on the buyer side. So that's how we define buyer agreement and the term buyer and home. Here's when the buyer agreement must be signed. It says it shall be executed between the buyer and the broker, but gives no firm timeline as to when exactly that must be done. So our law purposefully does not set a timeline. We will see what the settlement provisions say regarding this, but for purposes of Louisiana law, there's no timeline where this must be signed, dictated by law. It does, the agreement shall include the amount of compensation payable to the broker, or the manner in which the amount of compensation shall be calculated. So again, we'll see in the settlement terms about how compensation must be ascertainable, clearly and objectively ascertainable, and not open-ended. Similarly, your buyer agreement under Louisiana law should either state clearly the amount or state clearly the way to calculate the amount so that it is ascertainable and it's not open-ended. And we've seen some questions regarding this topic about, open-endedness, so to speak. And one of the things we've seen is, if you set the compensation, but then additionally add a provision to say, well, it could be reduced if these things happen. From our interpretation, setting compensation, but then saying, well, it might be reduced if somebody's willing to pay a portion, or it might be reduced if this happens. Those types of things will indicate that the compensation really isn't fixed. It really is kind of open-ended because it might be adjusted at some point based on things happening. So that's not like, that's different than being open-ended to the extent that it's based on a percentage of price. That we don't see as open-ended, and that's not what the rules say. What is open-ended is if you're unclear how you could possibly calculate it, or how it might change, or how it might be reduced or increased based on factors that haven't occurred yet. So be wary of trying to include those kind of provisions where compensation goes up and down rather than being set in advance and clearly ascertainable. The buyer agreement may provide that sources of broker compensation may include, but is not limited to, either funds from a buyer, a seller, a listing agent, or any combination thereof. So we will talk a little bit more about sources of compensation, but essentially this is laying out the fact that you, as the representative of the buyer, can enter into an agreement with the buyer that dictates who may be paying you, which may include the buyer, the seller, or the seller's listing agent. So all of those are possibilities, and any combination of that is a possibility. And then we have some exclusions where it doesn't apply. So again, we talked about commercial, it doesn't apply. And then leasing, as Kim said, when a person leases, this does not apply. You do not need a buyer representation agreement in the context of a lease because they're not buying and they're not a buyer as that term is defined. So that's an additional clarification. All right, so this is directly from the LR website, and this is a good comparison of the state law requirements versus what we've deemed as NAR requirements. And to be clear, that's, requirements sort of imposed by the settlement that are now being pushed down through MLS policy changes. But the NAR requirements for MLS participants, you must have specific and conspicuous disclosure of the amount or rate of compensation and how that amount will be determined. State law, very comparable, very similar in that regard, is that we must state the compensation or how it will be calculated. And we also say we'll describe the services that the broker will provide to the buyer. The requirement that the rate must be objectively ascertainable and not open-ended. The state law does not specifically require that. The state law agreement, and we'll go back to it, it says the amount of compensation payable to the broker or the manner in which it's the manner in which it can be calculated. So you'll see that's a slight difference. But at the same time, you will be subject to this requirement that it be objectively ascertainable and not open-ended, as long as you remain an MLS participant. And so, you need to comply with that provision. A statement that you cannot receive compensation from any source over the amount or rate in the agreement. So we've seen several questions on this, several proposed forms of agreements that may include this type of language. The idea here being that you would agree, with the buyer to receive a certain amount, but if you can get more from the seller, okay, I can go get more from the seller. That is prohibited. We have also had questions about, well, if I enter into it for a certain amount, right? Let's say it's for 2% of the sales price, but the seller is willing to pay 3%. How do I address that, or how do I deal with that? So number one, your agreement should not state up front that you can get more if the seller is willing to offer more. That's clearly prohibited. The question is whether or not you can potentially amend your existing agreement if the seller is willing to offer more. We have not seen any super clear guidance from NAR on this particular question, but I think in general, what we would be concerned about is, not having the full disclosure and knowledge of your buyer as your client before entering into such an amendment. But if that conversation comes up, and if that issue comes up, and you have that conversation and can get clear understanding of the facts and get a clear written amendment to your agreement, that is not prohibited as we see it currently. So again, not something we're promoting or encouraging, but it is a question that has come up. Conspicuous statement that the broker fees and commissions are not set by law and are fully negotiable. This does not need to be included under the state law requirements, but it does under your MLS participant requirements. And again, that's just a simple statement that it says exactly that. And that should be included in all of your agreements going forward. All right, so this is a brief summary of the basic buyer agreement. And so this is the simplest form of the buyer agreement that we've created. And this kind of goes through each of the relevant provisions with a brief description of what that provision is intended to address. I will go through this in greater detail, but I wanted you to see this short version of the summary so that you had that in your back pocket and understood that it's out there, and you can go back and refer to that if at any time you wanted to. So we'll get into a little bit more detail with the buyer representation agreement. Some of these slides are a little wordy. I won't go through every word because it'll take us too long. We're limited on time, but key point on this particular slide is that the statement that says buyer grants broker the exclusive right to represent buyer. So we are creating an exclusive agreement. And that's important to know. And it's important that you have that conversation with your buyer about what exclusivity means and making sure they understand that it prohibits them from entering into similar agreements with others without possibly violating this agreement. And again, you know, we talked about all the other provisions about when the agreement must be in place. The NAR rules require a buyer to have a written buyer agreement in place before touring a home with the buyer. Working with a buyer and touring a home is in the NAR FAQs. And they've kind of, you know, tried to outline when that occurs. They have very clearly stated that if you are a listing agent and a buyer calls and says, hey, I want to see this house, and that buyer's unrepresented, you can show them that house. You are working as the listing agent in that case. You are not working on behalf of the buyer. If at some point that relationship changes and the buyer asks you to assist them in some way in presenting an offer or representing them, then you would, you know, have to enter into that buyer representation agreement. But showing a home to a buyer when you are working on behalf of the seller and representing the seller only does not constitute a situation where you need a buyer representation agreement. The next one is about broker duties. So this establishes the duties and services that you're going to provide. In our basic form, we have a fairly short statement that is essentially a restatement of the law in Louisiana about what brokers' duties are to their clients. And that's really kind of it. We've gone with, again, the basic form for a purpose to try to give you something short and fairly simple that you can use to explain to clients and keep it, you know, less complex and less detailed. And that's what this statement does is try to go to just the basics of what your duties are as a broker. However, if there are other services that you intend to provide or that your buyer expects you to provide, you can certainly amend this to add those in that section about what services you will provide. All right, so this is the compensation section. Again, this is the basic version, and so we've gone with a basic option of a gross purchase price percentage, a flat fee, but we've also included a box for other if you want to establish some other method of payment, which you are free to do. And we certainly encourage people to use options and to offer options and to think creatively in establishing compensation rather than feeling like they need to stick to either a percentage of sales price or a flat fee. Not suggesting you have to change, but it's certainly there for you and the opportunities there for you to do that if it makes sense for you. The next statement says it's not set by law and is fully negotiable. Again, that's that simple disclosure that we're trying to make sure we include in all our agreements so that we comply with the settlement and with the MLS requirements. And the section C, same thing. You will not receive compensation from any source that exceeds the amount or rate of compensation above. So you are not going to get, you know, $3,000 from the buyer and then go get another $1,000 from the seller or any other seller party. So that part is clear. And then finally, we've said that buyer may request any seller party, which is defined later, to pay all or part of this compensation. So again, we're still establishing the right of the buyer's broker to receive that compensation from others, whether that be the seller or the seller's broker. That's still a possibility. And you'll see the various sources of compensation: the seller, seller's broker / listing broker, and the buyer. So each of those are still possible as potential sources of compensation. All right. This one's just a little bit further more about the same section of the agreement. Again, we talked about providing consumers with choices to compensate buyers' brokers. They're not limited to one type of compensation. So again, you can use any combination of these if you wanted to. In the other section, say it's percentage of gross purchase price plus something else, or you can use it in the alternative. Bonuses and financial incentives are not prohibited, but proceed with caution. So you'll see some acceptable language based on timing. If you close early or close on a certain date before, you get a bonus. Not acceptable, except any bonus or developer offers if buyer closes on one of the developer's homes. So this type of bonus structure is an open-ended, not clearly ascertainable compensation. The 3 bananas, we know how much 3 bananas is, and so that's clear and objectively ascertainable. All right, responsibility of buyer. So this just clarifies that the buyer is ultimately responsible to pay the broker. We want to make sure it's clear that the buyer knows that there is the possibility that others, meaning the seller or the listing broker, may compensate the buyer's broker, but ultimately it's the buyer's contractual responsibility to pay that compensation. And of course, if you get to a point where you come to a closing and the seller or the listing broker has agreed to pay some or all of your compensation as the buyer representation or representative, then that will be addressed at that time in whatever manner needed for closing. So we're not, prohibiting the ability to do that. We're leaving that part possible, but we need to be clear that if the seller or the listing broker does not pay your compensation, that the buyer is ultimately responsible for that. You'll see a recommendation here that you make sure that it's the buyer, emphasize that it's the buyer's responsibility to compensate their broker, and de-emphasize that a buyer's obligation to compensate their broker for their services may be reduced or eliminated through the negotiation process with the seller. So this has come from some consumer advocacy groups who I think are concerned about the idea that buyers are unclear about how they'll pay and where the payment will come from. So please make sure it's clear to your clients that they will be responsible for payment unless you're able to come to an agreement with the seller or seller's broker on that.
And Eric, I just want to point out on that consumer groups, they really pushed that the actual written agreement be clear about that. But let's be clear, in your conversations with them, I think it's important to point out there are other sources and really talk to them about those sources and how the burden is on them to really tell you that they want those sources, because down the road we'll talk about how the buyer is in the driver's seat and has to request certain things. But I just wanted to stress that.
Got it. Thank you, Kim. So when compensation is earned and owed, again, this is the basic agreement. So we have a fairly basic provision, but basically it says if you purchase a property during the term, or if you purchase within X number of days after the termination. So you can fill in that blank for however many days you want to. And it also says if left blank, it'll be 180 days. So if you have shown a property to a buyer during the term of the agreement, and then 3 weeks later that buyer purchases, assuming you haven't filled in the blank with a shorter period, you would be entitled to compensation at that point too. So I think that's fairly typical in terms of how most buyer representation agreements have been drafted in the past. I don't think that's a departure from sort of the norm. Term of the agreement, this is kind of standard throughout all of our forms. We leave it open-ended so that everyone can fill in their own term, but we do fill in the blanks if you fail to fill in the blanks. But we do also have this provision that says it shall be automatically extended through the closing or termination of any purchase agreement. And again, purchase agreements defined down below, but if you've entered into a purchase agreement during the term of your agreement, and the closing just hasn't happened yet, this agreement sort of automatically gets extended until such time as that closing occurs. There is we got a note down here about signing a buyer agreement before touring a home. We understand that buyers may be concerned about the idea of committing to pay compensation to a buyer's broker when all they're doing is asking to go, tour a home first. So you can suggest that the term be shorter. right? And fill in a shorter term so that the buyer is, committing to a 2 or 3 day term and then is free to kind of move on after that if they don't want. So that is a solution to the concerns of a potential buyer about entering into a robust agreement like this solely for the purposes of touring a home. And again, you can customize the dates for the beginning and the ending of the agreement. Designated agent is really just, the licensee who's going to work directly with that buyer on a regular basis. That can be more than one person, obviously, if you want to. But we put in a provision that just allows for that. And the state law does kind of define that term. We've essentially defined it the same way. Exclusivity, again, we're sort of reiterating the fact that this is an exclusive agreement and what that means. And you will, see that the buyer confirms that it's not entered into any other agreement with another, whether it's a broker or otherwise, to provide services similar to those that you're providing as the broker. So there's a statement by the buyer to do that. We've also had the question of what if the buyer has entered into that type of other agreement? Obviously, you'd want to have a conversation with that buyer about, well, who was it? When was it signed? What homes did you see with that person? So you get a real clear picture of how that agreement may have expired or terminated and what properties may be subject to any compensation or commission based on that prior agreement. I don't think this changes, how you should operate sort of in the past, in that you would probably have that conversation with the buyer beforehand anyway, right? And make sure that you're clear if they've already entered into an agreement that would require them to pay some form of compensation.
And Eric, do you have any suggestions for, like, say that a member on the call is in a exclusive buyer agreement and they just aren't going to work with them? They decide not to buy. Is there anything that a buyer's broker agent could do to maybe minimize some issues in the back and about which homes were shown, which were not, which they worked with them on?
Yeah. So and I think we have maybe talked about this in some other communications, but a good practice would be to send a list of properties to your buyer when the agreement expires or is terminated and say, to be clear, these are the properties that I have either shown to you or I have made the availability of those properties known to you, or the existence of those properties known to you, and clearly lay out that list of properties to the buyer so that you can minimize any disputes or misunderstanding about what properties you may be entitled to a payment for by giving that sort of follow-up disclosure. And that's certainly a good practice. And I know a lot of people do that already. And similarly on the listing agreement side with respect to potential purchasers. So I think that's probably done by a lot of folks and it is a good practice. Also, just a note, we have all of our agreements as exclusive. There is absolutely no reason why it has to be. So you can enter into a non-exclusive agreement if you so choose. We did clarify that this is creating an agency relationship. And again, we basically just relied upon the law with respect to the LREC and what that says about agency relationship. And we've indicated that, you should provide the form or pamphlet, and the definition of what agency means is down below. But in short, if you're providing these types of services to a potential buyer, then you have created that agency relationship and should consider yourself to have to comply with all the rules related to that. Termination, we have allowed either party to terminate in writing at any time without cause. So again, it doesn't take away the right to extend any payment obligation that occurs as stated above. But if you no longer want to work with a buyer, you can terminate the agreement, and vice versa. They can terminate the agreement if they no longer want to work with you, again, without surrendering your right to receive compensation in certain instances beyond the expiration or termination. And again, as Ken mentioned before, we have, you create a list of homes that you've brought the existence and availability up to the buyer, and hopefully to be signed by both parties prior to termination or expiration. But obviously, if the other side's not willing to sign, you can at least put that list together, send it to them, and you've got it in writing, so that you've created that paper trail about what properties you show. All right, buyers. We've had some questions about this statement. This is taken straight from the standard form purchase agreement, but I will agree that it's a little bit confusing because it says, if there's more than one entity or person named as a buyer, you shall execute multiple matching agreements. It really should say may. But the idea here is that, if you got more than one person or entity involved and you need multiple agreements, you can certainly do that. But you don't have to have separate matching agreements if you have two buyers and they both sign the same document. Here's our definitions that we looked at kind of throughout the course of looking at the agreement. Hopefully all these make sense. Broker is the undersigned broker, and we've said, and the designated agent, if any, unless the context clearly dictates otherwise. So in terms of like payment obligations arising, it's the payment is to the broker. So the context clearly dictates that. But in terms of services to be provided, the designated agent is kind of deemed to be part of the broker for that purpose. We define brokerage services as generally as just those services being provided. Again, the buyer is fairly simple. Property, again, we're excluding commercial, and we're talking about just residential properties. We kind of define what a purchase is so that it's more than just acquiring, fee simple title to a property. A purchase agreement, we talked about that, and we would suspect that this is on the standard form purchase agreement that is required by LREC, but it's, a written agreement where you've, agreed to buy and sell a property. And seller party, this is one where we try to make clear that when we're talking about a seller party, we're talking about both the seller and all of its representatives, agents, brokers, and licensees acting on that seller's behalf. So that's why it's drafted the way it is, so that we can be broad in describing the seller. All right. And then this is just the signature page. It looks very similar to sort of standard form purchase agreement, has all the requisite information in it. And you'll see a statement down here: the broker or a sponsored licensee acting under written authority of the sponsoring broker must sign. So again, just make sure that if the broker signing, that's fine. If the sponsored licensee acting with written authority, the broker signing, you check that box so that it's clear who's signing on behalf of the broker. And you see a note here to consider reviewing your written authorizations for licensees to ensure that everyone who's signing is authorized to do so. All right, so we've been through the basic agreement. What we wanted to do is provide sort of a short summary of the differences between the basic agreement, the short agreement, and the long agreement. So each of these, again, are available on the website, and you'll see with respect to location of the property. With the basic, we've just said it's any property in the state of Louisiana. With the short and the long, we've indicated that you can list the parishes, but if you fail to do so, it'll apply to all properties within the state of Louisiana. So you don't have to list the parishes. The exclusivity, we did a simple statement that says this is exclusive. We'd add the same in the short form, essentially. In the long form, we've got a more detailed statement about exclusivity and about the risks of a buyer who enters into a secondary agreement or has entered into a prior agreement with another broker, and how that might result in conflicting or I guess concurrent obligations to pay compensation. So we did add a more robust statement in the long form about that. The agency, again, we're just in the basic form indicating that an agency relationship exists. In the short form, we added a little bit more detail about what that means. And then in the long form, we added, again, a little bit more detail about agency and what it means and disclosures, so that the buyer is clear that, the applicable law applies to this relationship and what our relationship is. Designated agent, similar forms, both fairly simple in the basic and short. In the long form, we've more clearly addressed how to substitute out as designated agent. So the broker has the right to replace the designated agent if they want to, and that does not require an amendment or consent of the buyer. You can simply do that. And then also address ministerial acts and others who might be acting on behalf of the broker, like office staff, in performing certain tasks in addition to the designated agent. So the duties of the buyer, we have no duties imposed upon the buyer other than payment of compensation in these agreements. But in the long form agreement, we have a fairly significant list of things that are expectations and obligations of the buyer, like providing accurate information, timely responding to requests for information, timely responding to communications, all those kind of things that we would expect our buyers to do. Those are all listed, and certainly you can add to that list based on your experience of what you would expect your buyers to do. But we do have that additional list of duties in the long form agreement. In the broker compensation, you saw the three options, right? The percentage, the flat fee, or the other. That's the same in the basic form. In the long form, we've included the right or the option to have a retainer paid by the buyer, and that would theoretically be paid up front. But we've also put in a provision where it's refundable or non-refundable, and sort of you can dictate the circumstances where that retainer would be refundable or not. So we added that extra part. Again, you can take that and remove it, or you can add it to the other versions if you like. We added in the short and the long forms a statement that essentially says, if your buyer is entered into a purchase agreement, but subsequently assigns the right to buy the property to someone else, you will still earn your commission and be entitled to payment. So we had heard from various people that this had become a problem, and whether it's trying to purposely circumvent payment of the compensation or not, maybe that's not the case, but this prevents against that happening. Term of agreement, we talked about that. Short form, all we did in the long form was kind of emphasize that the term itself would be extended based on having a purchase agreement in place, and maybe emphasize that a little bit more. Termination, terminable by either party, as we discussed. So that's the same throughout all. Let's see, definitions. We added a definition for the term professional service provider into the long form, and we'll talk about kind of what that means down below, but otherwise the definition should be consistent throughout. Dual agency in the long form, we address specifically if dual agency arises, what that means and what disclosures are required. So obviously by signing this, you're not necessarily creating a dual agency relationship, but what we want to do is bring to buyers' attention that that's a possibility in the future should your buyer representative also be working on the listing side and have a home that's perfect. They might bring that to your attention, and if they do that, then we've got to discuss dual agency, and we've got to comply with the disclosure requirements related to that. So professional service providers, this is essentially people who you might refer to the buyer for services like appraisals, inspections, repairs, that kind of thing. And if you refer your client to those people, we are trying to limit your liability to the extent that that person maybe doesn't do a good job, or your client's not happy with their services. So what we basically said is, I'm giving you the names of these people and they can provide the service, but I'm not making any representation to you about how good they are, or that they're the best in the world, or that they'll do a perfect job. It's up to you to decide that. And in that regard, a good practice is to provide a list, right? And not just provide the name of one. So if they ask for a roofer, you might give them 5 or 6 roofers and say, here's the ones that I know in this area that have a good reputation. Do your homework to figure out which one's best for you. So that helps avoid some of those issues as well. The acknowledgements. So this is kind of just a clarification of what the broker is going to do and what they're not going to do. So it's an acknowledgement by the buyer that, hey, broker is not going to be responsible for getting an appraisal done. Broker's not going to be responsible for determining if the purchase price is the right price. That's all obligations of the buyer to decide for themselves, right? Or to engage those professionals, whatever the case is. Limitation of liability. We just included a provision that kind of limits liability of the broker for acts of third parties or things outside their control. It's fairly simple and straightforward. And then in the miscellaneous section, we added in the short form some electronic signature provisions and some provisions regarding how entities may sign an agreement. And in the long form, we've added that, plus we've added notice provisions, how to send notice and what method of delivery is proper for notice. Non-waiver, meaning if you fail to fully enforce the agreement right away, you're not waiving your right to later enforce it. Severability. So if one provision of the contract is unenforceable, the remainder of the contract is still enforceable. Attorney's fees. If there's a dispute, the prevailing party is entitled to attorney's fees. And then electronic communications, each party consents to receiving communications electronically, and the fair housing provisions that are in the standard form purchase agreement. So that's the differences between the forms. Again, modify, take, borrow from each one as you see fit to get an agreement that works for you. All right, so the next topic is compensation disclosures. And these are things that are required based on the practice changes, and these are disclosures with respect to the buyer agreements first. So for all current and active buyer representation agreements entered into before August 17th that don't contain a statement that the commissions are not set by law and are fully negotiable, that should either be amended or a separate disclosure can be provided to satisfy that disclosure requirement. So let me be real clear. You don't have to do both, amend and disclose. You can simply send that disclosure. And we will be putting together or publishing some sample disclosure statements and some sample amendments to address these issues. And we'll talk a little bit about that after this with the listing agreement side. So the new buyer representation agreements should include that language on the front end that broker commissions are not set by law and are fully negotiable. So in all your future agreements from here on out, you should have that language. And of course, all of our standard forms have that language in them. All right, so listing agreements, slightly different. You will need to address current or active listing agreements entered into before August 17th when there's no accepted offer by amending or a separate disclosure to satisfy the disclosure requirements about commissions. And it says disclose the compensation payment to a buyer broker is not set by law and is fully negotiable. All right, that's the disclosure requirement, same as before. The listing agreements that have a requirement that the broker disclose compensation or payment to a buyer's broker through the MLS must be amended to remove that requirement. So this may be a very small subset of listing agreements. Not every listing agreement, or maybe not even a majority, is going to have an absolute requirement that the broker publish on the MLS the fact that cooperative compensation, as it was formerly called, was being offered. But if your agreement says that, you need to amend that agreement to remove that requirement. Otherwise, you can just send the disclosure and you don't need to amend, and you can disclose that it's not set by law and it's fully negotiable. Again, for all new listing agreements, you need to include a statement that it's not set by law and it's fully negotiable. If the listing agreement is not a government specified form, which in Louisiana it's not, so we're not worried about that. All right. So in terms of listing agreements, what can your agreement say about compensation going forward? So this is just a sample. This is not prescribed by anyone or anything. This is just to be used as an example and for discussion purposes. But here's a sample listing agreement where you'll state up front very clearly in all caps and bolded, broker compensation is fully negotiable and is not fixed by law. All right, so number one, you have to have that statement somewhere in there. We suggest you do it as conspicuously as possible. Then we would have what I would consider to be sort of the typical language. Seller will pay broker compensation in an amount equal to, and you can obviously change this however you see fit. But this establishes, what the amount of compensation will be. We want to make sure that the amount is clearly ascertainable and objectively ascertainable, and not open-ended. So again, this would satisfy that because you'd either put a fixed amount or a percentage of the sale price. And again, we have kind of language about how you might get paid despite the fact that the closing doesn't occur during the term of the agreement. So then we go on to buyer's broker compensation. So if, you know, your seller is interested in offering some form of buyer's broker compensation, then this is where you would address that. And so here we've got a statement that says buyers may retain a broker who represents the buyer's interests. We define that as the buyer's broker. They might be entitled to compensation from the buyer, and you have no obligation to pay that broker. However, you may choose to offer some or all of the compensation owed to that broker as part of your transaction. And the amount of that, if any, shall be determined by you, the seller, right? So we're making it clear that you've explained to the seller that they have the option to do this, not the obligation to do that. And if they want to do it, they will determine the amount that will be offered. And here we have a box where a seller would check, yes, I authorize the broker to disclose to prospective buyers the willingness to negotiate with buyer regarding the payment of buyer broker compensation, or no, I do not authorize that thing. So first we have that first authorization is, can you disclose to a potential buyer that you're willing to pay some form of compensation to the buyer's broker or not? And again, we're authorizing the willingness to negotiate that amount. We're not authorizing the disclosure of a particular amount in this section. So the next section is, if you have taken the step of authorizing the willingness to negotiate or disclosing that, do you want to also further market and advertise that fact? And if so, how you would do that? So this is an opportunity that if you wanted to do more than just simply have a one-on-one conversation with a broker on the buyer side about your willingness to negotiate, you might have a publication of some sort, a pamphlet, a website where you list this, again, not MLS and not, you know, in violation of any MLS rules or regulations, but some other way in which you would disclose that. And that's available, and that's an option. To be clear, what's prohibited is using the MLS to disclose that. What's not prohibited is using other means, lawful means, to disclose that. And so we go on to further state that if you want to, if the seller has authorized you as the listing broker to go out and offer some form of compensation, how much is that compensation going to be? So you've got a blank there. And again, you can revise that however, or you've got the alternative where broker must obtain seller's approval in writing in advance of any disclosure or advertisement. So you can get the upfront, you know, agreement from the seller that you can disclose, and if so, how much. Or the seller can say, no, I want you to come back to me and ask for permission and consent before I go and offer any specific amount to anybody. Either one is workable. We like to provide options, have that discussion with the seller about how that would work and what it would look like. I realize that some people would probably say it's impractical to go back and ask the seller every time. So certainly, you know, you can explain to the seller the difficulty this might impose in terms of practical considerations. But at the same time, make sure you have that conversation and make sure they know that it's up to them, the seller, to decide when and if compensation is going to be offered, and if so, how much. All right, so this is a question we've gotten a little bit and wanted to make sure we touch on it. The question about, essentially it's come up in the idea of seller concessions a lot, and the term seller concessions has been used. I think somewhat kind of leading people astray from thinking that seller concessions is the only way that compensation can be paid by a seller or seller's broker to a buyer's broker. That's not necessarily the case. A commission type of payment or a compensation can be paid by the listing broker to the buyer's broker, as long as that's clearly laid out in writing and agreed to by all parties involved. But in any event, the way Louisiana law is currently written, it addresses the potential of a buyer broker compensation being included as part of the closing costs paid by the seller. And the law states that that cannot be done unless the compensation is disclosed in a written offer, accepted by the seller, and you specifically state the amount of compensation. So the key elements there is disclosed in a written offer. That can be the purchase agreement, right? So it can be something else, but the purchase agreement, when submitted by the buyer to the seller, is a written offer. So if your purchase agreement includes in it a statement that seller shall pay as part of his closing costs, compensation to the buyer's broker in the amount of X, that would be included in writing in the written offer. Of course, it has to be accepted by the seller. So if the seller countersigns that offer and the purchase agreement then becomes binding, you've got acceptance by the seller of that term. And you need to state the specific amount of the compensation. So again, not open-ended, needs to be objectively ascertainable. If it's a percentage of the purchase price, a fixed dollar amount, something along those lines is acceptable. So
And Eric, you know, we've had some discussion with the risk management subcommittee about, you know, being specific about gross or net. And also, could you touch on maybe some of the things we talked about yesterday about, you know, the need to be specific and detailed, so it turns out where the seller doesn't end up paying, you know, his broker something and then another broker something, and how we kind of visited about maybe wording things to make sure that doesn't happen.
yeah, absolutely. So there was questions raised both at the NAR webinar Kim and I attended and by others about how do we make sure that, given all the various players and parties involved, and now we're interjecting the idea of seller concessions that might pay some form of the compensation, how do we make sure that nobody's getting double dipped on? Nobody's having to pay twice for the same thing, right? So if the buyer and buyer's broker have entered into an agreement and it says buyer's going to pay compensation of $5,000 upon closing, and now we've got a written offer by the buyer to the seller and says, you know, seller is going to pay to the buyer's broker compensation of $5,000. Well, now we've also got a listing agreement that says that seller is going to pay the listing broker, you know, X number amount. So we have these potentially dueling or conflicting things, but we want to make sure that through the course of entering into these things, we're very clear about the fact that if, you know, the buyer's broker is getting paid from the seller, that is going to eliminate or reduce the obligation owed by the buyer to the buyer's broker. And I think our buyer representation agreement takes that into account, and it says that. But, you know, make sure that's clear of every time there's a payment, who's the source of the payment, who's the recipient of the payment, and how does that affect your other payment obligations that might be owed by those particular parties, right? I know that has the potential for creating some confusion, but I think it can be worked out through the course of the negotiation, whether it be in the purchase agreement or, you know, in disclosure documents executed at closing, to clarify who the source is and who the recipient is, and whether or not that relieves someone of another obligation they might contractually have to their broker.